TCC Judgment 113 宪判7 2024 Case on accruing previous seniority in salary assessment for certified substitute teachers. High notes. Article 35, paragraph 2 of the Teachers Act, as amended July 19, 2000, is constitutional. It is in accordance with the doctrine of specific authorization regarding teachers' remunerations laid out by J1 Interpretation Number 707. Article 12 of the Regulation of Contracted Substitute Teachers and Part-Time Substitute Teachers in Elementary and Junior High Schools and the Ministry of Education letters, a lot of letters, are unconstitutional for violating the division of powers between the central and the local governments under Article 108, Paragraph 1, Subparagraph 4 of the Constitution. Letters 2, 3, and 4, Article 10, Paragraph 1 of Supplement Regulation on Contracted Substitute Teachers and Part-Time Teachers of New Taipei City Municipal High Schools, Junior High and Elementary Schools, and the first sentence of Note 3 of the criteria for assessing salary for public schools and preschool substitute teachers issued by the Education Department of New Taipei City Government are unconstitutional for violating the equality principle under Article 7 of the Constitution. Background note: substitute teachers, either certified or uncertified, are relief teachers who stand in full-time for regular teachers when they are taking a leave or unable to perform their teaching duties. Substitute teachers are generally employed in high school and lower-level schools, elementary and junior high, which can be further categorized into national schools, private schools, and county municipal schools. However, the remunerations guidelines on whether to accrue seniority of the past teaching jobs for substitute teachers vary in different regions, level types, or schools. Because they apply different regulations, some stipulated by the Ministry of Education, some by local governments. Questions arise as to whether these distinctions and additionally the differential treatment between substitute and regular teachers violate the constitutional principle of equal protection. The petitioner was a certified substitute teacher contracted by New Taipei Municipal High School in 2017. When assessing the petitioner's salary, the school referred to the criteria for assessing salary for public schools and preschool substitute teachers and discounted his seniority also as a substitute teacher in two other public high schools. After unsuccessful administrative appeal and exhaustion of ordinary judicial remedies, the petitioners filed for constitutional review. The petitioner argued that the relevant regulations and letters violate Articles 7, 15, and 23 of the Constitution for creating different treatment in the remunerations of substitute teacher. The petitioner also argued that the J1 Interpretation Number 707, which ruled on the legal authorization of remunerations regulation for public school teachers, should be supplemented. This case was argued on March 12, 2024. Judgment 113 宪判7 was announced on August 9, 2024. Summary of the judgment. Holding. 1. Provision 1 prescribes that the rights and duties of substitute teachers be stipulated by Ministry of Education. Hereinafter, MOE issued regulations. It did not violate the doctrine of specific authorization. Provisions 2, letters 2, 3, and 4 issued by MOE, which authorized the local government to stipulate the supplementary regulation regarding whether to accrue previous seniority when assessing the salary of certified substitute teachers in high school, lower-level schools. The New Taipei City Government and its Education Department amended and issued Provisions 3 and 4, which supplemented the regulation on accruing seniority of previous teaching experience of said teachers. Within said scope, the provision and the letters violate Article 108, Paragraph 1, subparagraph 4 of the Constitution. Letter 2, 3, and 4 issued by MOE as well as Provision 3 and 4 issued by New Taipei City Government and its Education Department prescribe that when assessing the salaries of newly employed certified substitute teachers, the high school and lower level schools may not accrue their previous seniorities. Within said scope, the provisions and latest violate the equality principle under Article 7 of the Constitution. The parts of the provision and the later declared unconstitutional in Part 2 and 3 of the holding shall cease to be effective at the least 1 year from the announcement of this judgment. The petitioner may, following this judgment and the relevant legal procedures, motion for a retrial with the court of jurisdiction for his original court case within 30 days starting on the next day of the day when this judgment was served. The rest of the decision shall be dismissed. Reason: Provision 1 conform to the doctrine of specific authorization. Following the decision of JY Interpretation number 707, the remuneration of teachers, including the assessment and standard of their salaries, is an important matter of public interest. Under said interpretation, it is constitutional to stipulate such matters with regulations, provided they are specifically authorized by the law. Therefore, it is constitutional for the legislators to set out Provision 1 authorizing MOE to stipulate the relevant regulation on supplementary and special matters regarding substitute teachers' rights and duties. The content and scope of Provision 1 authorized were specific and clear, which conform to the doctrine of specific authorization. 2. Whether to accrue seniority of previous teaching experience for certified substitute teachers in junior high and elementary school is a national matter and shall be stipulated with unified regulation issued by central government. 1. Regulatory framework for the remuneration of certified teachers. Provision 1 authorized the MOE to stipulate regulation regarding the remuneration of certified non-regular teachers in junior high school and elementary school. With the authorization of Provision 2, which was in Provision 1 authorized regulation, MOE further delegated the competence to lay out the supplementary regulation to local education, administrative education. Additionally, the MOE issues letters 234, clarifying that the school may accrue previous seniority when assessing the salary of the certified substitute teacher upon employment, just as the regular teachers. However, the local government may decide depending on their fiscal conditions. 2. The central government has legislative discretion over the educational personnel system, which also contains the remuneration standard, including the assessment of salary of certified substitute teachers. Education is the cornerstone of national development. The quality of teaching could indirectly influence the people's right to education. Because teachers serve a crucial role in the education system, the design of teachers' personnel management, including training, certification, rights and duties, shall belong to the legislative discretion of the central government, as required by Article 108, Paragraph 1, Subparagraph 4 of the Constitution. Substitute teachers in junior high and elementary schools are full-time education personnel, just like the regular teachers. Under nationwide factors such as declining birth rate, delayed retirement of regular teachers caused by pension reform, and changes in curriculum that result in decreased teaching hours, local competent authorities have taken action to reduce the number of regular teachers. Their measures lead to increasing employment of substitute teachers who function the same as regular teachers. Many of the substitute teachers also have administrative responsibility or serve the role of homeroom teachers. From this perspective, if one school denies accruing a certified substitute teacher's seniority of the previous job, when assessing his or her salary, it would have the same effect as the other school enjoying said teachers' teaching experience elsewhere for free. If this issue is not managed with a unified national standard, it will cause unfair fiscal burdens between local governments, as well as insufficient protection to the certified substitute teachers, which violated the protection of educational workers under Article 165 of the Constitution. Therefore, whether to accrue a certified substitute teacher's past seniority is a matter regarding the education personnel and the educational system, which belongs to the legislative discretion of the central government. Conclusion: the MOE did not issue specific regulation on the accrual of the past seniority of certified substitute teachers. Instead, the MOE delegated the competence to stipulate such regulation to local government with the provision to Letter 2, 3, and 4. This allowed the local authority to decide on their own, depending on their physical conditions. This may lead to inconsistent practice and unequal distribution of teachers between regions. Such effects would further affect the people's right to education under Article 159 of the Constitution. The said provision and later did not conform to a decision of the General Interpretation number 707. Within this scope, the said provision and later violated the division of the power between the central and the local governments under Article 108, Paragraph 1, Subparagraph 4 of the Constitution. 3. Later 2, 3, and 4, and provisions 3 and 4 stipulating that the high, junior high, and elementary school may discount certified substitute teachers' seniority from previous teaching experience when assessing their salary, have violated the equality principle under Article 7 of the Constitution. 1. The case shall be reviewed under intermediate scrutiny. The regulation in question used the status of whether one acquired the position of regular teacher as the criterion for differential treatment. Under such a distinction, the local government may decide if the school should accrue the seniority of a previous job. Such a criterion is not an immutable characteristic. However, considering Article 165 of the Constitution prescribes that the state shall safeguard the livelihood of those who work in the field of education, and shall, in accordance with the development of the national economy, increase their remuneration from time to time. Furthermore, as I mentioned before, General Interpretation number 707 deemed that the remuneration of teachers are important matters involving public interest. The differential treatment imposed by regulation in question shall be reviewed under intermediate scrutiny. The regulation in question could violate the equality principle, and it was doubtful whether their purpose served an important public interest. The differential treatment under the regulation in question is based on the formative factor of whether one is a regular teacher. In doing so, the regulation in question have neglected that in practice, certified substitute teachers are manpower equivalent to regular teachers. Past teaching experience of the certified substitute teacher are not properly evaluated under the regulation in question, leading to unequal pay for equal work, which could violate the equality principle. The MOE expressed in Letter 2, 3, and 4 that the local government may decide, depending on their physical condition, whether the school shall accrue certified substitute teachers' seniority of previous teaching experience. However, the design of education is important for the generation to come. It concerns the overall literacy of the citizen and national development. Sufficient protection for livelihood of a certified substitute teacher would elevate the equality of teaching. Subsequently, it would also protect the people's right to education and advance education in rural areas. Whether to accrue the seniority of the certified substitute teachers should not be based on physical burden alone, but should also on important public interests such as protecting the right to education and advancing the education in rural areas. It is doubtful whether the regulation in question, which listed the reduction of physical burden as their main purpose, are of important public interest. 3. The differential treatment imposed by regulation in question was not substantially related to its purpose, even if alleviating the physical burden of the government was an important government interest. The MOE failed to provide accurate statistics to elaborate why discounting seniority could evidently achieve it. The differential treatment imposed by regulation in question was not substantially related to its purpose. Moreover, the accrual of seniority of certified substitute teachers should work the same as a regular teacher, because in practice they have already shared almost the same teaching and administrative responsibility. Conclusion: the regulation in question did not pass the review of intermediate scrutiny. They violated the equality principle enshrined in Article 7 of the Constitution.